If you own rental property in the City of Spokane, there's a new Eviction Prevention Ordinance you must know about. It changes what has to be in your lease package, your rent increase notices, and your pay or vacate notices. Ignoring it can cost you time, money, and even your eviction case. Starting June 1st, 2026, Spokane's Pathways to Eviction Diversion Ordinance is in effect. Under this ordinance, every housing provider in the City of Spokane has new duties before they can move forward with an eviction, especially for non-payment of rent. The practical change for landlords is this. You now have to provide an Eviction Prevention Resources Notice form to your tenants at key moments in the tenancy. So when do you need to use this form? 1. When you sign a new lease with a tenant. 2. When you renew a lease or sign an extension. 3. When you send a rent increase notice. 4. When you serve a 14-day pay or vacate notice or other pre-eviction notice for non-payment. Think of it as a standard attachment anytime you're changing rent, renewing, or starting the eviction process. If you're not including this notice, your paperwork is not compliant with Spokane's rules. The Eviction Prevention Resources Notice is a multi-page document created by the City of Spokane. It's designed to do three things. First, it tells tenants about rental assistance programs that may help cover what they owe. Second, it explains their access to mediation and dispute resolution, where a neutral third party helps you and the tenant try to reach an agreement. Third, it explains tenants' rights to legal help if an eviction case is filed, including free or low-cost representation for qualifying low-income tenants. In other words, the form puts all of the who can help you and how information in one place. The ordinance also builds in a diversion period before you can file an eviction for non-payment. Here's how that works in practice. After you serve a pay or vacate notice and the Eviction Prevention Resources Notice, there is a 30-day window where the focus is on an amicable solution. During that time, tenants can apply for rental assistance, request mediation, and reach out for legal advice. Landlords are expected to participate in good faith. That means responding, attending mediation sessions when requested, and working with the city's diversion program rather than just waiting out the clock. If you skip that process or treat it as a box checking exercise, you're increasing your risk when you get to court. So what if you don't use the required form or you don't follow the diversion steps? A few things can happen and none of them are good. A tenant's attorney can argue that your eviction case is defective because you didn't comply with the ordinance. A judge can delay your case, require you to restart the notice process, or even dismiss the eviction. You may lose a month or more of time in rent simply because the paperwork wasn't served correctly. In some situations, failure to follow the ordinance can be raised as a defense in the unlawful detainer action and can affect the outcome of the case. If you own rentals in Spokane and you're not sure whether your notices and lease packets are up to date with this ordinance, I'm here to help. You will find a link to the form and the city's explanation in the description below.